All right, the meeting is now being recorded. So the Board of Trustees regular meeting of October 26, 2021 of the Public Defender Service Corporation is now called to order. Will the secretary please call the roll?
Chief Justice F. Philip Carbolito.
I am present and I am logging on from my chamber at the Guam Judicial Center.
Presiding Judge Alberto C. Lamarana III.
So he is excused. He's in transit on his way back to Guam, and he gave us notice of his status.
Trustee Cynthia B. EQB.
Present, and I am located in my law office here in Hagåtña, Guam.
Trustee Donna Muñoz Canata.
I'm logged in my office here in East Hagåtña, the Guam on the spot.
Guam Bar President Jackie T. Terlahi.
So we have 3 of 5 members present, and we do have a quorum. And
Your Honor.
Yes.
The Guam Bar President Terlahi said she would be coming in a bit late. She will be here.
All right. Okay. I duly noted for the record, and we do have a 3 of 5 members present, and we have a quorum, so we can act. We have enough members to act and conduct our regular meeting of October 26th. So with that, the first item on the agenda is the approval of minutes of the regular meeting of September 28, 2021. It's a motion to adopt the minutes.
I'll
Motion.
move to approve the minutes of, Your Honor.
All right, it's been moved by Attorney Cynthia Ekubi and seconded by Trustee Donna Kanata. Any discussion? There being none, all those in favor, please say aye.
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 Those opposed, the ayes have it. And so the minutes of September 28, 2021 are duly adopted. The first item on the agenda under old business is the financial status update. And I recognize the controller, Mr. Mike Moreno.
Thank you, Your Honor. Good afternoon to the court members. For Public Defender Service Corporation and the alternate public defender, we are presently at 48%. We received our final allotment release for fiscal year 2021 on October 1st. And the first allotment release for October 2020 for the fiscal year 2022 was received on October 21st. Being that this week is also a payroll week, we anticipate another allotment release, hopefully by next week. And for the domestic violence program, we are still invoicing all services except sexual assaults to the ICJR funding. And the Stop 20 funding is on hold at this time. We're not using the funds yet. It's just an additional funding just in case we need it. And as a side note, the payments for EJC billings have been received for the months of March through July. Receivables as of today are from August for billings for August and September, which amount to 41,211. The grant funding has been exhausted at the end of September 2021, and we are waiting for the officially signed MOU for fiscal year 2022. That concludes the reports for the finances. If there are any questions.
I'm sorry, I kind of missed that towards the end. You mentioned about the funding for the Elder Justice Center. Can you repeat?
Sure. The payments for EJC billings have been received for the months of March through July. And as of today, the receivable is at 41,000. The grant funding for fiscal year 2021 has been exhausted and has been used up as of September 30th, 2021. At this time, we're still waiting for the officially signed MOU for fiscal year 2022 to continue the program.
All right, we'll address those issues when we get to the Elder Justice Center item on the agenda.
Sure.
Thank you, Mr. Moreno. The next item is the report from the Executive Director. Mr. Hattori, you're recognized.
Thank you, Chief Justice. Could I share a screen? I wanted to just show the slides from
Yes,
our
please.
report. So basically, we compiled stats on the number of total cases. This chart shows the cases that we opened from every year from 2017 to last year, 2021. If you'll notice, 2021 we had 1,105 cases, and which is a far cry from 1753 in 2017, right? And so the part of the decrease is obviously related to the Attorney General's office. They have a pre-trial or pre-charge diversion program in their juvenile matters. If you'll look at the column for juvenile JC, juvenile drug court, and JD cases, we went from 290 in 2017 down to 44 in 2021. So the entire fiscal year of 2021, we only opened 44 juvenile delinquency cases. Of course, our guardianships went up, and we also increased, like our war claim case went up, as well as our protective orders, and our PINS cases went from 32 in 2020 to 56 in 2021, which is really the most number of PINS cases we've had in the last 5 years. Right? Basically what this boils down to is an average caseload per attorney of about 69 cases per attorney, assuming we had all 16 attorney positions filled, and assuming we were able to equitably balance the caseload. Right? And so it's gone significantly down since 2017, when we had 109 average cases per attorney. This one is the case opened by attorneys. And so you'll see that there is some disparity between the different attorneys and how many cases they opened. We try to create a balanced caseload, but it never really pans out that way. And I think a lot of it has to do with the types of cases. For example, like Mr. Highsmith has 116 cases that were open, but of those, he's handling pretty much all of the protective orders. So there were 64 protective orders. It was really a rough year for protective orders, as well as 4 civil restraining orders. And so that would explain why his numerical bump is higher than everyone else's. He also is handling all of the probate, the war claims. This is helping heirs of the survivors who were entitled to the war claims payments recover the monies after the survivor has passed. And so that's something that there was a law passed by the Speaker Terlahi, designated our office to assist with that. So that's also a large, resulted in, I guess, 24 cases last year. We anticipate that number is going to be going up if there was a new bill that became law regarding the payment of war claims. And so, that just gives you an indication of what our current numbers are. And I wanted to share with you a different, who is that? Oh, sorry, I'll share this one. I wanted to share with you other, so this one shows in fiscal year 2021 that we actually closed 1,000 cases. 389 of these were probably probation conditions were met. It looks like we had 35 cases were closed because income was exceeded. 30 cases were closed through to a dismissal with prejudice. 47 were closed through a dismissal without prejudice. 127 were dismissed and expunged. These were probably a combination of ADC and family violence court. 33 cases were dismissed without indicating whether it was with or without prejudice. 7 clients were deported. 1 was closed, I guess deferred. 13 passed away. These 45 consultation cases, most of these are like notice to appears. And some of these have not been charged, so we close them out. If they are charged, then of course we represent them in the criminal matter. We closed 113 due to conflict, which is significantly less than what we had in the past. There were 7 that were closed due to acquittals. 26 were substituted out by private counsel. And then, I don't know, there's this 87 probation terms were completed. So sometimes they'll be closed due to probation being completed, and other times they're indicated that they're ordered closed. We assume because they've completed probation. So those are some of the numbers that show, that we are closing cases. We also have another sheet, and this sheet, we didn't provide this because it's so bulky, right? We actually identify our felonies based on type. This is an example of one belonging to Zachary time ago. But the reason I'm sharing this with you is because if you look down at the bottom, it shows our cumulative numbers. So we actually have 4,146 cases that are not closed. And of these, 2,036 are post-judgment, and 293 are post-judgment with a bench warrant. We have 1,161 active pre-judgment cases and 493 pre-judgment cases with bench warrants. So that basically about 15 to 1,600 cases are actual pre-judgment cases that are open and awaiting a resolution. Okay, and so those are some of the numbers that we wanted to provide them. I'm going to provide some other information later on when we get to the BJA and our Sixth Amendment Center initiative. All right. Do you guys have any questions?
Yeah, I do, Steve. So with the reduced caseload of the Public Offender Service Corporation, which is also tracking our experience here at the judiciary, is there an opportunity to assign at least one attorney temporarily, full-time, to the Elder Justice Center? I'd like for you don't have to answer that question right now. I'd like for you to examine with the reduced caseload and the identified need in the Elder Justice Center, if there is an opportunity where we can temporarily assign maybe 6 months to 1 year on a full-time basis, one attorney from the 16 who can then assist the Elder Justice Center. Do you have any thinking on that?
And I think that would be a really good idea. I think the numbers would support it. And I think we could also, if we moved over our protective orders and, the civil restraining orders, that would, and we were able to put them at the same wall, again, at the other side of the wall, then that would really reduce conflicts, because we, unfortunately, some of our conflicts are caused because we do protective orders and we do restraining orders. And so we've had to weigh the benefits of pursuing a protective order versus the conflict that it may cause if there are criminal cases that arise out of it. So, but in the ideal world, the protective orders would be in the same side of the house as the EJC, so it would not be causing conflicts. We think we could reduce conflicts if we were able to accomplish that.
Well, I'd like for you to put together a plan in consultation with Kathy Seguenza of our Elder Justice Center, if this is something that will be welcome, and that based on the data, there seems to be the work, and maybe it'll reduce the need to then assign out these cases and actually have the capacity and capability to undertake the work, and rather than assign the cases that incurs the cost to the Elder Justice Center. Because this, what I am contemplating is this attorney full-time will be paid for by the budget of the Public Defender Service Corporation. And so it won't tap on the budget of the Elder Justice Center, in addition to the staff that we're going to look at later in this in this agenda. So I'd like for you, Steve, to report back by the next board meeting the result of you examining this question, and with a recommendation in consultation with Attorney Seguenza in identifying the personnel and the office space, and like you said, the caseload that can correspondingly be handled by this one attorney. And just my quick look at the caseload, and based on my knowledge of what the attorneys of the Public Defender Service Corporation had been handling in the past, this may be an opportunity to help out the Elder Justice Center until we figure out the longer term funding for the center. And so I'd like to examine that and have a report from you at the next Board of Trustees meeting.
Yeah, thank you, Chief Justice. And when we really want to provide more services than we can, right? The grant can only pay for so much. So if we are able to allocate another attorney and double the amount of services we're able to provide the seniors, it still won't be enough, but at least it'll be a really great start. So we'll prepare a report for that for the next board meeting.
All right, thank you.
Okay,
Any questions, comments by the trustees to Mr. Hattori? There being none, we will move to the next item on the agenda, which is the report of our managing attorney for APD. And
Hi, Your Honor.
Annie Gale, you are recognized.
Thank you, Your Honor. Could we go to the, we provided stats as well, Your Honor. Can you go to the JT to page, there we go. These are the numbers. What we've experienced, the same with the public defender, is our numbers are lower than in the past, but we still have already hit 400, which is higher than we did higher than we did last year during pandemic. We're still in the pandemic, but as you know, the courts have opened a lot more. We're going to court a lot, appearing telephonically, Zoom, and in person. So the first two slides are showing the cases per attorney and the numbers, total numbers. If you go to the last slide, the 5-year comparison, one more. The last one, JT. Next. There we go. We're at the top of this table. It's a blank that should say felonies right there, and it's blank, but it should say felonies. So compared to 2017 to 2021, we have 209 versus 177. But back in 2017, we did have more cases, 473 cases. So the trend has been up and down, but we're still trying to hit the 400. At least we've gotten the 400 cases. We do have appeals, we do some civil work, some special proceedings, juvenile PINs, juvenile delinquents. As Steve mentioned, the cases for juveniles have gone up and down, with a lot more being filed from 2017 compared to 2021. I'm really not sure why there's such a big drastic difference in that. For our attorneys, the average is about 80 per attorney, which excludes Mr. Dirks. Mr. Dirks is just covering, he does mostly magistrate hearings and arraignments, so he doesn't carry a caseload. Anyway, that's basically it, Your Honor. I'm not sure if you want me to explain anything else. If you have any other questions, we're still working on our cases and everything. So if you have any other questions, I'm be more than willing to answer. Thank you.
Thank you, Annie. I don't have any.
Okay,
questions.
thank you, Your Honor. The one who always has questions is Judge La Morena, and he's unfortunately not here. I'll make sure he sees these though, because he's always interested in seeing the numbers.
Correct.
Thank you, Your Honor.
All right, so the next item is our Elder Justice Center, and I will recognize Attorney Kathy Seguenza. Kat, you are recognized.
Yes, thank you, Your Honor. It's funny, Annie, you say that. I did all my data for the judge, for the presiding judge too, because he told me that he likes numbers. So I hope he looks at this. I'm really happy to let the board know that during our 6-month pilot program, we exceeded the requirements of our MOU with the Department of Public Health. Basically, and where's my presiding judge, La Morena, we addressed all 371 cases from waitlist 1. While we were doing that, we handled 91 urgent cases that came in, as well as 69 services from a second wait list, which gave us a total of 531 services in 6 months. We've attached that, exactly there, thank you, JT, which is, I think that's pretty admirable for 6 months. At the same time we were working on these, calls kept coming in, and we continued our outreach and continued to keep wait lists. So as of yesterday, we have 741 more on our new wait list. So we've got our work cut out for us. I'm thankful, Your Honor, for your suggestion for another attorney, because clearly that's the next step for the EJC. Thank you. Oh, and one last thing, Charlene San Nicolas is on the line, and she will explain to Your Honor about the status of the contract. My understanding is that the Public Defender's Office has signed off completely, and Charlene will let us know where it is from the public health standpoint. Thank you.
Good, that was going to be my question, Charlene. What's the status? We don't want the staff to be working without compensation, so please inform us.
Okay, so as of this time, as of October 21st, the amendment for FY22 is at the Office of the Attorney General. We are going through the contract signatory review and routing process for at least our contracts on the aging side. So once it's cleared there, it goes to the governor's office, and then from there down to Department of Administration for contract registration. Typically, we get invoices for our services 10 working days the next month. So we anticipate before then that the contract would have already been registered. Funds are available for the October, November, and December. We are working with our own fiscal office at the department level for the remainder of the funds for the fiscal year.
So Charlene, I'd like for you to give us heads up in terms of Kathy and of course Steve Hattori and Kathy Gogui. You know, in reference to if there are issues with the funding, I don't want to see our staff working for 1-2 months only to find out that there is an issue with the funds. If it's a matter of it lagging behind because of the processing, That's another thing that administratively, Steve and Kathy Gogwe can maybe address. So, but at this time, what is being processed is the first quarter operational funds. And is that how it operates? That we only draw down on a quarterly basis?
No, not typically. Pre-COVID, we usually get our local overmatch on side of the funds to provide for more periods of service. So right now, for this, at least for this fiscal year, we have 3 months. We anticipate when we get our grant awards, of course, we will look at where we're at, how many other additional funding sources to then extend the agreement with the funds available.
So when will that information be available to public health in terms of the grant funds and whether or not this program is going to continue to be funded in part by the by Department of Public Health?
Yeah, so we had our monthly call with our grantors. We were informed that because this grant receives partial federal funds, we anticipate receiving grant award notice sometime next month. They didn't specify when, but that's the first increment of grant funds. Right now, our funds are done through congressional continuing resolution. So as Congress clears and provides the funds, then we will be provided our additional notice of awards for this program. This is one of 6 other programs under the supportive services site.
So is the processing of the paperwork in reference to the review by the AG, the sign off by Public Defender Administration, the review by the AG, and the signature of the governor in reference to the MOU and of course public health before then, is this an annual document or is this subject for a quarterly processing every time the funding is identified?
It's not annual. It's subject to the availability and certification of funds.
All right. Okay. Well, that's good to hear. I suspected that was the case, but I just didn't want us to wait to process the documents if it was a quarterly obligation. Okay.
Your Honor,
So
excuse me, Your Honor, may I have this opportunity just to introduce 2 people? Today is a big day at the EJC. It's the first day of our brand new special projects coordinator. Her name is Gwen Potter Diego, and she's here just to say hello. Can you? I think yeah. Can you see her? That's Gwen, and we've also started. Public Defender was kind enough to begin the sharing process, and we're sharing a legal clerk, Kailani Regis. And they've been doing great. So thank you, Steve and Kathy Gogwe.
and hopefully they'll be able to add a lawyer to the staff, and so we'll try and work that process through. All right, so that completes the report for the Elder Justice Center, and we'll act on the resolution under new business. But for now, we'll go to the next item on the agenda, and that is the BJA Sixth Amendment Initiative. And Steve, I will recognize you on this topic.
Thank you, Chief Justice. Can I share my screen? I want to have to put on a slideshow. Howdy, Your Honors and board members. Thank you for the opportunity to provide a summary report on this Sixth Amendment focused initiative. Back in June 15, 2021, Lisa Vavanese actually provided a presentation on the Sixth Amendment initiative that our office participated in. The board had asked for the reports, a summary of the findings, our strengths and weaknesses, and our recommended action. This presentation will go over these items and end with our action plan. So here are the 4 reports. One was the January 2019 initial site visit report. There was an August 2019 report. There was a holistic defense policy scan report, as well as the final report. The 4 reports have previously been provided to the board. The July Board of Trustee agenda included the first 3 reports, and the February Board of Trustee agenda included the final report. And so these reports identified our strengths and weaknesses. It was really a collaborative effort between our technical advisors from the Center for Court Innovation and the PDSC and APD staff. Many stakeholders were interviewed, including justices, judges, other attorneys, probation, the Department of Corrections, DYA, and the AG's office, as well as clients. First, we'll discuss some of our strengths and weaknesses, and then the action plan we developed. So a few of our strengths were the quality of our PDSC APD staff and representation, our communication with clients, and ensuring our clients' voice and understanding of the process. Generally, stakeholders felt attorneys within both PDSC and APD were both experienced and talented. Other stakeholders mentioned how the majority of PDSC staff are dedicated, very, very dedicated, and they want to do the right thing. Importantly, this statement was echoed by former clients who felt well represented by both their appointed PDSC and APD attorneys. In general, all stakeholders reiterated, and this was also heard during the site visit interviews, that PDSC attorneys and management are committed, experienced, and generally offer a high caliber of representation to the people of Guam. And that's from the August 2019 report. One stakeholder said, I think overall they do the best they can for the people. I know other peers too that can't say bad about it. Like, they agree that they were represented properly. Even if they weren't getting paid enough, I've seen some compassionate attorneys just like go out of their way. That's from the January 2019 report. Next slide. And other examples of our strengths include improved indigent representation at magistrate hearings. I think this, we started appearing at magistrate hearings. That's the initial appearance where people have been arrested. They're brought before a judge within 48 hours. We're able to advocate for their release and also argue against restrictive conditions of release. This also helps us, we weed out conflicts at this point as well. So we get a summary report. We see that their current cases might cause conflicts. And so at that point, we inform the magistrate judge, and then we can have APD appointed directly at the magistrate hearing. So APD also appears at all the magistrate hearings as well. Another strength was that our stakeholders noted that they do recognize we have fewer conflicts. If we look at our stats, in 2016, we had 207 cases that were closed due to conflict. In 2017, it went to 164. 2018, we had 154 cases closed due to conflict. In 2019, it was 147. 2020 was 122, and in 2021 we had 114. So part of the reason the number of conflicts have gone down is because we appear at magistrate hearings and we identify conflicts even before we are appointed. I think another reason is just the general overall decline in criminal cases that are being charged. But I think also it was some internal discussion among our office about the standards for withdrawal, right? I mean, we argue all the time about whether or not it's the same or substantially related matter that justifies a withdrawal. And so we're hoping to keep our numbers down. And I think that it affects the entire defense system. I'm pretty sure the private attorney panel costs have gone down as well over the last 4 or 5 years. A couple other strengths are our improved juvenile indigent defense team. We basically have 4 attorneys: Will Jones, Earl Spiritu, Christine Bora, and Kathy Uggan. each maintain a small number of criminal matters to ensure that they have the time necessary for their representation in the juvenile cases. And this process really has been facilitated by the court's current case assignment system, which designates 3 judges to handle juvenile and civil matters. So attorneys assigned to those courtrooms do not pick up criminal cases as regularly. And I think, part of it also really the AGs deserve some credit under Carol Hinkle Sanchez's pre-charge diversion program. I mean, the stat we cited earlier was we had 290 JD cases about 5 years ago, and last year, fiscal year 2021, we picked up 44. And so a significant number of cases, either crimes going down or the cases are being diverted. But, something positive is happening out there, and, and maybe it's reflected in the reduced number of cases being charged in the adult side, right? Stakeholders also said that, we're doing better at improving representation by offering more training, applying for the Sixth Amendment initiative. Part of it is we've developed performance standards through our involvement with the Center for Court Innovation. We've conducted like the Shanks Criminal Defense College. We haven't had that for a while because of the pandemic. We also joined as an office the National Association of Public Defenders. This is the source for most of our training, which generally is online at this point. We've conducted over 30 hours of CLE in the last 2 years. And through the CCI, the Center for Court Innovation, we've collaborated with Jack Cutrone and NLADA, which is the National Legal Aid and Defender Association, to develop our adult and juvenile performance standards. This resulted in a site visit and a half day of CLE for our attorneys, and we continue, to work on our performance standards. PDSC and APD have each sent an attorney to the National Juvenile Defense College. We have sent attorneys to the Appellate Defender College as well to try to improve our services in those areas. Our stakeholders also said that the quality of our communication with our clients appears to be high. The clients that were interviewed expressed that they felt that their voices mattered in their relationship with their attorneys. Clients mentioned that they understood the process of criminal court, their rights, requirements for compliance, and outcomes. One of our clients actually said, "My voice mattered. If it was something I didn't agree with, then I asked questions for clarity purposes, and it was explained to me." Of course, we also had challenges. So those are the strengths. We do have weaknesses in the office that we have identified with the assistance of our stakeholders. And, we're working on addressing these deficiencies. We call them challenges. One of the first one identified was case processing delays and caseloads. This is something that the stakeholders indicated that there were, after interviewing various judges, attorneys, former long-term clients of PDSC and APD, and there was even a group interview with judges that were recorded. They lasted about an hour long, and they basically resulted in the identification of these challenges. So the case processing delay, they said it was based on unnecessary court hearings and appearances and delayed discovery by the AG's office, which affected our ability to prepare defenses for our clients. I kind of personally disagree with this core issue, and I think it really reflects the opinion of the stakeholders and clients that were interviewed for the study. Different judges have different ways of managing their docket, and specialty court judges, they had to ensure clients were being pushed through, like they would have to be legally screened first by the AGs, then they would have to be clinically screened by the treatment team, and then at that point, if they're eligible for treatment court, then they get the plea agreement, and there's a change of plea. And so treatment courts do require more hearings than traditional courts, and that, but it does vary from judge to judge. There was an issue regarding delayed discovery. Others mentioned that the AGs do not provide discovery timely. And this is something that, we've been working on. As an office, we do request discovery pretty much even before arraignment. It's a standard motion that we all make. Another concern was lack of preparation by defense counsel. They indicated this wasn't as true for trial type cases as it was for general cases. So that's something that we definitely need to do. Meet our clients more often and meet with them in a more private setting rather than on the courthouse steps, right? Some stakeholders felt that the time standards inadvertently has drawn out cases, and obviously I don't really agree with that. I was here before the time standards, and cases were really being dragged out back then. And right now, we have 4,146 cases, but only 1,161 of them are pre-judgment. Prior to the time standards, it was not uncommon for there to be many more pre-judgment cases that would be dragged out. So the second challenge, early communication with clients. There was some feedback saying that our communications was positive, right, with our clients. However, our early communication with clients from the time they're arrested until maybe through arraignment and their first trial setting, especially for confined clients, I think obviously, that's an area that we are definitely working on improving. Our time standards will address that. We've worked on some other methods of meeting our clients, and that we'll discuss later. Number 3, insufficient time spent with clients prior to arraignment. Historically, our office has really not met with our clients prior to arraignment except to discuss the arraignment. We don't have problems meeting our confined clients. The concern was with those who are out of custody, and those, so we've changed policies to make sure that they meet with someone before they're actually arraigned. In the past, we would, if our clients, they're released from jail or they're charged with a case, they don't necessarily show up at our office before arraignment to get processed. So we often would meet with them outside the courthouse steps and try to hurriedly advise like 15 to 20 clients of their various rights and what's going to happen with the case. And that's really doesn't do anybody justice, right? And so we've started requiring our clients to come to the office. And so we would go to arraignment. If they have not been processed by our office, then we ask the court to order them to come to our office to get processed. And then we would meet with them and go over the basic, rudiments of the case, right? Like the type of charge. A lot of the charges are for DUIs, family violence, or drug offenses. And, so we kind of allay many of their fears and concerns about what kind of jail time they're facing if they're convicted, right? I mean, so we do explain like first offense DUI and what drug court's about and what is involved in a family violence diversion or deferred plea. And so I think we've addressed this concern. Number 4 is pretrial detention and limited pretrial diversion. So some stakeholders were concerned about the lack of best practices on Guam related to pretrial detention and diversion. They said they were concerned that law enforcement would just arrest and book on almost all charges, and then the AG's office would, feel pressure to do something with them. There was some concern that there wasn't any established pre-arrest diversion program, and that's not something that we really can control other than advocated with the Attorney General's office. So we've entered discussions with them about having a family violence diversion program restored, because that has fewer consequences for our clients and would, we believe, increase the amount of reporting. For example, like with diversion, it's not really a deportable offense because they don't enter a plea of guilty, but they do go through all the treatment that they would go through had they pled guilty. Currently, with a deferred plea agreement, some of our clients are deportable, and the clients that are deportable often have like 3 to 5 children who are U.S. citizen born and raised on Guam, and they are either left without a parent or they have to get uprooted and follow their parent back to wherever. And so, you know, we're that's something that we're trying to work on. The fifth challenge was pretrial conditions set by judges. You know, our attorneys are advocating for a reduction in some of these conditions. And some of these conditions are things like being having the ability to drive, even though you've been arrested for a DUI, or being able to maintain your sole form of identification, which for many people is a passport, so that they can actually go get a Guam ID, or they could, you know, maintain employment. And so we try to advocate for that. Another concern by our stakeholders was overuse of probation, and that I think this one was just that that they find that the staff of our office often contacts them to either have them remind our clients about an appointment or try to get an updated phone number. And you know, unfortunately, the courts order our clients to report to probation to update the information, but they're not ordered to report to our office to update information. So we're usually the last ones in the courtroom to know that our clients moved and anything. So as a last resort, you know, we do use probation to get updated contact information for our client. A few more were funding and resources. Stakeholders, of course, mentioned that we have problems with funding. There is a resource gap. They indicated that there was a problem with recruitment. And these are things that we're, you know, trying to address through different, you know, different manners, right? We're trying to work on some sort of, you know, we have to work with the AG's office and the legislature to address these issues. Number 8, lack of training opportunities. You know, generally historically, there really hasn't been a lot of training opportunities for defense counsel. I think in the last 6 to 8 years, there seems to be a lot more grants that are available for defense attorneys. So we are trying to take advantage of that. We also are sending more of, you know, our attorneys are involved in, you know, CLE, in office house CLE, but we have sent some off island for specific training, whether it's the National Juvenile Defense College or the Appellate Defense, the Appellate Criminal Defender College. 9 was a concern that we don't represent very many people in the appellate section. We are definitely hoping to change this. I mean, when I first became director, I would jokingly say, like, my goal is to have our office handle more appeals than Levin Camacho, because at one point he was doing very many of the criminal appeals. And so we are trying to increase our presence in the appellate world, right? If we are going to be the top criminal defense firm on the island at the trial level, we really need to also get better at the appellate level. And so this is an area that we have been working hard on to try to improve. I think we try to maintain appeals. We've identified attorneys interested in doing appeals, and we are working on getting them the training to do so. One of the other concerns was the inclusion of the civil and elder abuse cases, our Elder Justice Center. The earlier report, there was concern that it would create conflicts and affect the overall quality of representation of our criminal clients. I think thanks, you know, the wisdom of the board, right? They said you guys can do it, but you have to create a conflict wall to eliminate the problems caused by representing, you know, people in civil matters. And so it's been fashioned after APD. All the elder justice cases are at the other side of the wall. And so it really isn't going to be causing conflicts and increase the cost of, justice on Guam. The other problem, currently we don't actually have any attorneys that are assigned there other than what the grant funds. So, but we believe that with the way we've been managing our cases and with the reduction cases, I'll prepare a report. Hopefully we can detail or provide additional legal attorney assistance to the Elder Justice Center. But I think we did address their concerns with opening the Elder Justice Center. Number 11, attorney-client contact. So, that's obviously, that's always a concern, the amount of contact we have with our clients, especially when they're detained. We've worked on various measures to address this issue, and we'll address that when we get to our action plan. Number 12, this was identified by our stakeholders that we need to be more holistic in our representation. I think, especially our probation officer colleagues, they're tired of seeing our same clients coming back in the system over and over, and they're hoping that if we can provide a holistic representation, then maybe we won't see as many of them, come back in the system. And so we have addressed that with the hiring of a social worker, and so we are, working on that. And so some of these, so the challenges led to suggested action items by our stakeholders. They all, of course, recommended things like increase early communication with clients, increase training opportunities for attorneys, reduce unnecessary court hearings and appearances, increase pretrial alternatives and diversion opportunities, routinely monitor attorneys to ensure they are meeting office standards, and increase opportunities for more frequent communication. Have a way for clients to contact PDSC staff more directly and consistently, invest in interpreters, translators, or staff with diverse language skills. And develop a informational material, increase early contact with detained clients. So we've actually acted on many of these recommendations. Clients now are given more than just our main office number, 475-3100. They're provided the direct line to their attorney secretary. Our off hours phone answering machine has every attorney's extension, so they can, if they know their attorney, they can get their attorney's extension and leave a message for them on voicemail. Confined clients, we had problems last year where they had to actually pay for their phone calls to their attorneys, right? And these calls were being recorded. We worked with the vice speaker. She introduced and passed the Inmate Phone Access Act, which is, it basically funds toll-free calls for indigent clients to call their attorneys, whether they work at the public defender, APD, or in the private attorney panel. And these calls are made toll-free, and they are used, they're basically also not recorded. And so right now, any client who's confined can call us, basically collect without incurring, and this one actually is being funded by PayTel itself. So PayTel, I mean, I'm sure everyone's aware, right? It's kind of a costly system to use. I think it was 15 or 20% of the profits go back to Gov Guam. Vice Speaker identified that as the funding source to pay for unlimited phone access to indigent attorney calls. We're also further increasing access with a BSP Burns JAG sub-grant that'll fund our Access to Counsel program. We're hoping to install video meeting computers in each of the detention facilities so that we can meet with confined clients. I mean, there is a system currently set up. It's pretty much used by the court exclusively. I've been able to use it on Saturday mornings. So, and when you meet a client through video conferencing, you can do things that you can't in person, right? Like to make a client listen to or view a recording, I would have to bring a laptop in, and it's a lengthy process. But when we conducted via Zoom, we're able to share the screen like I'm doing now, and they're able to read along to their plea agreement or watch along to a video type evidence. So that's another way we're hoping to increase contact with our confined clients. Another subgrant that we received is through Uptrust. It's a client notification system that keeps clients informed of court hearings and appointments. So what that is it's a web-based text notification system. The AG's office uses something similar called Vine for victims of crime. And each day or a couple days a week, all the appointments and court hearings that we've logged into our case management system are uploaded, and Uptrust will send text messages to every registered client about their next court hearing or attorney-client visit. And I mean, I've been getting positive feedback from my clients that, yeah, they got it. And I mean, there are some kinks that we have to work out, but generally it helps inform them about future appointments and hearings. And so that was another subgrant that we pursued. And so after these, the suggestions by the stakeholders, our office, met as a team, and we developed our own action plan. The action plan consists of various things that we want to work on to basically improve the quality of our representation. The first one is the attorney performance standards. We basically, we worked on the juvenile adult defense standards. Will Jones basically led the charge on the juvenile defense standards. Those are actually complete. At some point, we'll have to get them reviewed by APD as well as by the board for implementation. The adult defense standards, they're very close to completion. I have to confess, we really should have completed it, but I hate to blame the pandemic, but really that kind of had something to do with it. And then I also, we've been spending a lot of time with the Outer Justice Center, but now that I have Kathy Moylan back and we've pretty much have everything under control, we should be able to finalize those attorney performance standards for the adults. We also recently heard from David Carroll, who's the director of the Sixth Amendment Center. The Sixth Amendment Center goes to various states and defense systems, and they do assessments and they make recommendations. So he informed me that he's on the verge of obtaining funding from the Department of Justice to basically look at our entire defense system on Guam to ensure that we're complying with best practices, and hopefully to make recommendations regarding how we can comply with the best practices. So another action plan action was the Holistic Defense Initiative and the hiring of a social worker. And so based on the policy scan that was conducted with the help of the Center for Court Innovation, we wrote up a plan to get a social worker. The board approved us requesting the hiring of a social worker. And during the pandemic, we appeared before the legislature, and they actually told us to fill that position, even though, back then we were kind of worried about the funding issues. But they recognized that a social worker can do much good for our clients. And so our social worker now, she's being stretched pretty thinly on so many different fronts. I mean, I have her working with the Homeless Coalition to help identify our clients that are homeless rather, and get them services. And she's also helping with PINS cases where we've been appointed guardian ad litem. A guardian ad litem in a PINS case is really it's kind of like they carry the heaviest load in a PINS case. because they're the eyes and ears of the court, and they go out, they do home studies, they interview, yeah, they do quite extensive reports, and it ends up, I think, being the costliest part of a PINS case, for the private attorney panel indigent defense fund. And so we've been picking up some guardian ad litem work, even though it's time consuming, but it eventually will save the court money. Number 3 is a conflict of interest SOP. So we had a conflict of interest rule that the board approved. We wanted to integrate how that conflict of interest rules would impact the staff and every division's involvement with ensuring that we recognize conflicts early and we withdraw timely. And so during the strategic plan, we did develop a conflict of interest SOP, and it seems to be working well. The whole team, not just the attorneys, are looking at conflicts now and we're trying to do it as quickly as possible so that they can get a new attorney to assist them. Improve discovery speed. There really isn't much we could do. We're already filing motions to compel discovery pretty much in every case. These standard discovery requests are made during arraignment orally, but they're always followed with a standard motion or request for disclosure. I personally, I think discovery's gotten a lot better during the pandemic. It seems everything's being electronically served now. So to me, the discovery's a little more timely than it was, say, 4 or 5 years ago. Another action plan was expanding jury qualifications. Admittedly, we haven't really been working on this. I know that there was some legislation we were expecting to testify on that would have actually excluded high school seniors and college students from the pool of applicants. It would have made them exempt from serving. And so that bill has not been scheduled for hearing, and we have not testified one way or the other on that. Another action plan that the team wanted us to work on. So these action plans were actually suggested by our own team, like employees and staff and attorneys at a public defender. So, they're a little ambitious. Number 6 is GPD interview protocol, body cameras, video interviews. This is something like we can advocate for, but we can't really change it. And so we are keeping an eye out for measures that would address these issues. We've identified jurisdictions where they're required to provide, record interviews, at least oral interviews, and but we haven't really been able to make much headway with this one. DMV record access. This would benefit our investigation division as we try to locate witnesses and our own clients. We did meet with DMV, I believe. We met with the Department of Revenue and Taxation, and we just need to work on the MOU to make this happen. Then, not to blame the pandemic again, but Rev and Tax has really been busy with other things, so we haven't been able to get much with this action plan. Number 8, funding for expert witnesses. Well, this was actually the board really helped out with that when they approved our budget last year. We did request for an expert witness fund, so we did receive about $22,500 for an expert witness fund. We just have to develop the procedure in which we intend on tapping it, because obviously we can't use it in every case, right? And so we'll set up a committee to review guidelines for when we can tap it, whether we have them apply to a subcommittee within the office or make a request directly to our fiscal division, and like first come first serve until we use up the $22,500. Number 9 was improved client contact, and this seemed to be a concern of our team, right? And we've worked on obviously that access to counsel program, the Burns diagram, where we're hoping to set up video conferencing to meet our clients at both at DOC and DYA. We were in discussion to actually have like a mini office at the Agana lockup, but the director had left or retired from Department of Corrections, so we were unable to complete that. So in lieu of that, we're planning on setting up video conferencing in each of the detention facilities, including the female unit. We anticipate a couple at the Manila facility and then Agana lockup in DYA. We also increased the ability of our confined clients to call us. I already discussed that PayTel. Now they're able to make collect calls using unrecorded telephone lines. And now PDSC, APD, and the private attorney panel we can receive collect calls from our detained clients who are unable to afford PayTel. And so the other ones I've already discussed, Uptrust, it really is like a $20,000 service that we basically, our share is $5,000 because we're a subgrantee from Uptrust. And just us getting that program was pretty, we were pretty fortunate. We reached out to various, like the Santa Barbara Public Defender regarding their use of Uptrust. We met with the San Francisco Public Defender regarding that as well. And so those are basically the items in our action plan. I think of course, the last one is the Elder Justice Center. That was this was part of our action plan, and it was developed all the way back in 2019, 2020. And so thanks to the board, we're able to address this number 10 on our list, right? I mean, under our enabling statute, we are required to render legal aid and assistance to those persons who are in the greatest economic and social need of legal assistance and representation. So the opening of the Elder Justice Center is one step towards fulfilling, our mandate. And so we anticipate assisting at least, providing at least 300 different services in the upcoming year with the grant. And if, we can convince the board to allow us to detail an attorney over there, then we might be able to we believe we'll be able to double that, the amount of Monoco that we can help. And so that's something we'll be working on next. So once again, I'd like to thank you, the board. I'm sorry this presentation was super long, and really it's like 5 or 6 months overdue, but we were tied up with our budget and the Elder Justice Center. So I really appreciate your patience. So we've completed basically 2 of the 3 areas of the strategic plan initiative. We've worked on the strategic planning services. We've received on-demand services. And the only thing we have left is the system-wide assessment that the Sixth Amendment Center through David Carroll will be conducting sometime in January. Our next steps, we hope, lay the foundation for a better and more holistic future for our clients. And of course, our gratitude to the board for supporting our office along the way. Right. Okay. Thanks,
you,
everyone.
Steve.
Sorry about that. It was kind of lengthy.
I thought that report was quite comprehensive and it was very informative for me. And so I very much appreciate the report. And I didn't realize how comprehensive the BJA Sixth Amendment Initiative was, and it's a very valuable survey and tool. And I encourage you to use it as a management tool and not just be a one-time review. I think something using the checklist and the best practices identified and reducing that to action plans is a good annual management tool to utilize to review the operation of the organization. And so I would encourage that the document be used and updated on an annual basis. And so you take advantage of the input from professionals who come in and are able to review the efficiencies and shortcomings of the organization. I also would suggest for you to consider utilizing some part of the lapses to build up your expert witness fund and not just rely on an annual appropriation. We know that that tool can be a very valuable tool in providing indigent defense at a level that provides the resources to your lawyers to help them in doing the work that they do. So you may want to at least a certain portion of it, or a small part, so you can try and build a nest egg, because we all know how expensive those services can be. And we'll continue to push and support that effort. But I want to thank you personally. That was very informative for me, and I would encourage that the document be used as a management tool going forward and update it on an annual basis. Now, are there any comments, questions by any member of the board? All right, so we'll move to the final item on our agenda, and that's the EJC board resolution. And if we can bring that resolution up on the share screen, and I ask that Kat Seguenza address this resolution.
Thank you, Your Honor. Essentially, the resolution parallels the motion that was made during the last meeting, and it establishes the EJC as a permanent division of the Public Defender Service Corporation, subject to the availability of funds. And the resolution memorializes the board's agreement to accept what we suggested as scenario D during the last meeting. And at the last meeting, the motion carried, and we were instructed to have Attorney John Morrison prepare this. And I think John did a great job. And unless, John, do you have anything to add to the resolution?
Attorney Seguenza, I think that really covers it. I listened to what was stated on the record at the last meeting and drafted this, trying to be as close to the language used as possible. And I think it speaks for itself and is exactly as you've laid it out.
Okay, thank you.
And I have reviewed the resolution and I concur. I don't have any suggested changes. And so at this time, I would request from a trustee member a motion to adopt the resolution.
Motion.
Your Honor, I have reviewed it too as well, and I would move to adopt this proposed resolution.
All right. It's been
And I will
moved.
second it, sir.
It's been moved by Attorney Ekubi and seconded by Trustee Donna Kanata. And so any discussion on the resolution? So this just kind of brings us
None.
to at a certain interval in our development of the Elder Justice Center, the involvement of the Elder Justice Center. It's a very important milestone in this effort. And so with that, I will call for the vote. So all those in favor of adopting the resolution relative to establishing the Elder Justice Center as a permanent division of the Public Defender Service Corporation, please indicate your support by saying aye.
Aye.
Those opposed, the ayes have it. and the resolution is duly adopted. So thank you, Kat and John, and all the staff members who worked and helped in drafting this resolution and continuing to support the Elder Justice Center. As you see, we're trying to continue to channel resources to expand the services of the Elder Justice Center. The data warrants that effort be undertaken. And so, so there will be other opportunities, I'm sure, down the line. So with that, that concludes our business for this month's meeting. I note for the record, first, is there any public discussion? Is there any member, any public discussion? I do not see any, there being none. The next meeting of the public defender will be on Tuesday, November 23rd, right before Thanksgiving. So I want to wish everyone a happy Halloween. Stay safe during the week, the rest of the week, and over the weekend. And I want to thank you for taking the time to participate in our meeting. With that, I would entertain a motion to adjourn.
I'll move to adjourn, Your Honor.
Second.
Been moved and seconded. There being no objection, the motion is duly adopted, and this meeting is now concluded. Thank you, everyone. Stay safe. Goodbye.
You too. Bye-bye.
Thank you, CJ.